Okay, so now we're going to talk about some civil actions that may affect nurses in the course of work. And now we're talking about a tort law, we're talking about malpractice. So tort is an a legal category. It's an action that's harmful to others. It doesn't reach the level of criminal. An unintentional tort is an unintended, unreasonable action. So this is something that someone did by accident that is still considered unacceptable by a reasonable, prudent person with that licensure. So this would be things like malpractice. For malpractice to occur, there have to be several conditions. There has to be a duty. So the person who commits malpractice has to have a duty to that person. So you can't commit malpractice against someone that's not your patient, for one. But also you have to have a duty to do a specific thing or to refrain from doing a specific thing. So what is the nurse's duty toward a patient? That's established by Nurse Practice Act. That's established by facility policies and procedures. An expert witness may be called to testify what a reasonable nurse would do. That's established by accreditation and licensing standards and by standards established by professional organizations. So for example, if I'm administering medications, I have a duty to administer medications safely to the correct person. And the standards for how that's done, those standards are established by the Nurse Practice Act. What medications can I give as an RN? They're established by accreditation and licensing standards by professional organizations that I have a duty to practice nursing safely. And in an individual facility, policies and procedures. So let's talk about insulin. I have a duty as a nurse to give the correct dose of insulin to the correct patient at the correct time. And that's going to include the correct type of insulin by the correct route. Did I get them all? There's the 5 rights. Okay. So if there is an order for an insulin drip on a patient in DKA, is that within the RN scope of practice? Yes. So I have a duty to administer that safely. And if I don't know how to administer an insulin drip because maybe I've been working in home health for the last 10 years and I've never done an insulin drip, which happens, then I have a duty to find out how to do that properly. If my facility policy is that insulin drips are always checked by 2 nurses, which is a good policy to have, then I'm responsible to that policy as well. So I have to make sure that I know how to administer it. I have to make sure that I'm following the facility policy in administering that safely. So if I fail to do that, if I fail to check that insulin with someone else, then I've breached that duty. So this is where knowing your facility policies and procedures comes into play. As an LPN, it's within the LPN scope of practice to give some IV medications. However, which medications and under what circumstances may be defined by facility policy. And if your facility says that first time IV pushes are administered by an RN and the RN says, hey, I don't have time, go give that push yourself. If you as an LPN administer that first time push, you now have breached your duty to follow the policies and procedures of the facility, which puts you at risk of malpractice. But having done something incorrectly is not in and of itself malpractice. So you have to have a duty, which is the right way things are supposed to be done. You have to have breached the duties. You have to have failed to do that. So I'm hanging my insulin drip. I failed to have a second nurse check that insulin drip. I also failed to look up how to give that insulin drip safely in the IV drug book. I just used maybe the cheat sheet posted on the wall, or asked the other nurse and they told me, and I didn't completely understand the direction, so I winged it. Okay. There has to be foreseeable harm. Well, is there foreseeable harm in hanging an insulin drip incorrectly? Yes, we can kill someone pretty easily. And then there have to be actual damages or injuries. So I can do everything wrong, but if that patient is not hurt, it does not meet the definition of malpractice. So I got lucky. But if that patient's blood sugar crashes and I don't check his blood sugar again for 3 hours, because I don't know the standard of practice for an insulin drip, and that patient has brain damage or dies from an extended hypoglycemic episode, then that's when I've committed malpractice. So malpractice requires a duty. Okay. That's how we're supposed to do something. A breach of that duty, we did not follow the correct process for doing that thing. Foreseeable harm, we should be able to predict, yeah, someone's going to come to harm if that happens, and damages or injury. Okay. Now, this can apply on an individual basis, but it can also apply on a larger basis. A facility has the duty to provide adequate staff for safe care. And if they don't do that, and if patients are harmed because of inadequate care, then they are at risk. They have legal liability. So that brings us on to liability. The concept of liability is who is responsible for harm. Okay, who is responsible for what has happened? Each person is responsible for their own actions. And each person includes people who are unlicensed. So unlicensed personnel are responsible for their actions. And if they perform actions outside the scope of their knowledge, they can be held accountable. A CNA is not going to be held accountable for knowing something that is within the RN scope of practice and not the CNA, but they are going to be held accountable for doing things that are outside the scope. So each person is responsible for their own actions. Physicians and independent practitioners, so that's would be nurse practitioners, PAs, midwives, those providers. They're responsible for the orders they give, but they cannot remove responsibility from a licensed professional. So when does that come into play? Say a provider gives me an order for a patient, and I believe that order to be unsafe. My first response is going to be to ask the provider for clarification, because sometimes there are things that I just don't know. And I've done that before and been told, yes, that massive dose of Demodex or Lasix was correct, and this is the mechanism of action. This is the rationale behind that. But if I still believe that that order is not safe, I can say I cannot carry out that order because it's not safe. And sometimes providers will say, do it anyway. It's on me because I wrote the order. And if they write it in an unsafe order and the patient is harmed because that's done, yes, they do have legal liability. But the licensed nurse who carried that order out knowing it was unsafe also has legal liability. So a provider cannot remove your responsibility for your actions. Okay. That means only accept duties from a provider or from an organization that are in your scope of practice, which you are competent to carry out. Another example would be, I spent a lot of time in labor and delivery. Before that, I worked on ortho neuro units. So there were med-surg units, but not like belly surgeries. I've never worked in an ICU. I've never worked in an ER. So if I take a job and I'm asked to be the ER charge nurse, I'm not qualified to do that. I don't know enough about how ERs work, and I don't know enough about emergency care of patients to be able to do that safely. And if I take that job and then I cannot carry it out safely, yes, my employer can be held liable for putting me in that position, but I can also be held liable for accepting the position. Respondeat superior is the concept that or the idea that if a person, either an employee or a subordinate, commits an act of malpractice and their superiors are responsible for that, and it has some limitations. Again, your employer or providers cannot take your responsibility away. You're still responsible for your decisions as a nurse. But an employer or a provider can be held responsible for putting someone in a position for which they're not qualified. If malpractice is committed working within the policies and procedures of a facility, so say the policies are not up to date and they require harmful actions, a nurse can be held responsible for doing those actions that harm, even though they're in the policy. But if a nurse is acting within the policy of the facility and harms a patient, the facility can also be held responsible. Nurses are in a position frequently of supervising other staff members. And that's going to be on like a patient level basis most of the time. But if we are delegating something to other staff members, then we must ensure that the task was properly assigned to a competent person, it was properly supervised and appropriately evaluated. So if you delegate something to another staff member as in a supervisory capacity, then you're legally liable for making sure that you're delegating those things to someone who is capable of doing them and that you supervise them. In most healthcare facilities, a lot of the personal care is given by unlicensed staff members. So maybe CNA, PCA, there's a lot of different names for that role, but there are unlicensed nursing staff members. They have a limited scope of practice. They can do personal care, they can collect data, they can do things that they have been trained to do that have steps that don't really change a lot and don't require judgment in the process. So we'll get more into that with delegation in a bit, but if, say, in my facility, CNAs are allowed to check blood sugars, but a particular CNA has not been trained to do that. If I delegate that to that CNA, then I'm still responsible for that blood sugar and I'm responsible for that inappropriate supervision. However, even an unlicensed person retains personal responsibility. So a CNA that is falsifying bathing and turning patients, falsifying vital signs, not completing tasks that are essential when they're supposed to be completed, they can be held legally responsible for that as well. Institutional liability, we've already talked a little bit about that. The institution has two major responsibilities. They really should have clear and current written policies and procedures. If there are not policies and procedures in place, then both the facility and the nurse can be at legal risk because it makes it very difficult to establish what the correct process would have been. That leaves place for a plaintiff lawyer to say, if there's no policy in place, they're just winging it and they did it wrong. But also institutions have a responsibility to have systems in place to prevent error. So in an institution, if a med error occurs because the system was set up in a way to make that error more likely, the system itself, the facility can be held responsible. Facilities should also be able to be held responsible for staffing and supplies and things like that. Students, as a nursing student, you are responsible for your actions and you can be held liable. You are held to the standard of a licensed nurse for the nursing actions that you perform. So if you currently have a license, but you are going to school for a different license. So as an RN student, you're going to be held to the standard of an RN for anything that you do. That means if you're going to insert a Foley catheter, you're held to the same standard any other nurse is held. That means using sterile technique, doing that safely. If you're administering medications, you're expected to administer those medications safely and correctly. So you're held to the same standard as the license that you're pursuing. The instructor is responsible for reasonable and prudent oversight and assignments, but you are not practicing on the instructor's license. If I take students to clinical and I give them unsafe assignments, I can be held responsible for that. If I take students to clinical and I have a student that goes off on their own rodeo and does something unsafe, when they've been instructed to do this, remain on this floor, they go off to another floor and get involved in surgery somewhere, that student is responsible for their actions, because a student is remains responsible for their own actions. As a student, don't accept an assignment for which you are not qualified. If you are nervous about an assignment, talk to your instructor. Ask your instructor for guidance. Always go back, communicate with your instructor. And if you're working with preceptor nurses, with your preceptor for guidance. Don't go off and do a procedure that you don't know how to do without instructor guidance. Okay, that's how you protect yourself as a student. As a student at Eastern, you have liability insurance that's paid out of your nursing fees. So we have a liability insurance policy for faculty and students out of your nursing fees. Yours, you don't pay for mine. You pay for yours out of your fees. Okay, defense to malpractice. What are adequate defenses to malpractice? If the plaintiff fails to prove any of the elements of malpractice, that's a defense. Statute of limitations. There's a limit to how long you can wait to pursue legal action in most cases. Assumption of risk. Assumption of risk means that the patient was informed of the risk of a particular medication, procedure, etc., and they chose to take on that risk. So for example, if a surgeon is going to do a fairly risky surgery, they make sure the patient is aware of the risk. I saw this a lot in neurosurgery, because there would be patients with really terrible life-threatening conditions, but the surgery to fix those conditions was also pretty risky. And the surgeon would have to be very, very careful explaining, if we don't do surgery, this is likely to happen. If we do surgery, this may happen. What's the percentage? What's the likelihood that's going to happen? And when that happens, the patient has assumed the risk. Now, the patient has assumed the risk of the surgery being performed correctly. If the surgeon then performs the surgery incorrectly, they can still be held liable for that. So assumption of risk, that has some limitations. That's going to be the normal risk with that particular procedure. And contributory negligence. So the patient has surgery. They are taught, this is why we document teachings, they are taught how to care for their surgical site. They're discharged to home and they don't care for their surgical site correctly. They expose it to contamination. That surgical site gets infected. They come back, sue the surgeon, the hospital, the nurses, everybody, because of the infection. If the defense lawyer can prove that they contributed to that infection by their own negligence, that's also a defense for malpractice. Evidence that can be used in a malpractice case. Anything in the medical record can be used in a malpractice case. When you chart, you need to be charting enough to show that you gave the care that was necessary for that patient. You need to be documenting what you do. If it wasn't documented, it wasn't done. Any personal notes that are kept by anyone involved can also be subpoenaed. So if you have personal notes and anyone knows about them, they can be subpoenaed. Typically, an incident or occurrence report, it's not part of the medical record and it cannot be requested unless someone mentions it. And if someone else mentions it, then the defense can request it. The most common malpractice suits against nurses are medication errors, falls in safety, equipment failure. And that means if the equipment failed, why is it the nurse's fault? If equipment's not working properly, it's your responsibility to get it out of rotation. So equipment failure, failure to assess, monitor, and obtain assistance, failure to communicate, failure to report. I have seen, and I need to look up the most current statistics, but in some years, the most common fatal error by nurses is failure to rescue. So it's not something we do, it's something we don't do. We see that med error, we see that fall. That's really, let's not let those happen. But a really, really common error that leads to bad outcomes is not noticing that our patient status is changing and doing something about it. So make sure that you're assessing your patient and addressing changes. Failure to communicate. You didn't communicate to the provider that change in status. You didn't communicate something critical to the next nurse. Those things need to be documented. That's why we document when we notify the provider of something. Okay, an intentional tort, that's all unintentional tort. Okay, we're talking about malpractice. An intentional tort is an intentional act that can cause harm to another that does not rise to the level of a misdemeanor or felony. Assault and battery, false imprisonment, defamation. And defamation is spreading incorrect, derogatory information about another person. If it's written information, it's libel. So if you're posting things on Facebook, it could be libel. If it's spoken information, it's slander. Privacy and confidentiality violations like HIPAA, there actually can be prison terms with HIPAA too. It can be criminal. Employment related, like interference with contract, intentional infliction of emotional distress. Now we're talking about bullying, sexual harassment, discrimination. The defense against intentional tort is going to be informed consent or advance directives. Okay, we're going to take a break, and in the next video, we're going to talk about delegation.